prior to the beginning of this meeting. We will allow Mr. Frampton 15 minutes to address the meeting hall. Mr. Frampton has not been given time to present to the public of a group of this size before. We will also allow him 5 minutes at the end of the public comment for summary. For those of you who have wished to speak, we've asked you to sign in, and we appreciate that you've done so. We'll follow the order in which you signed in to provide a sense of organization to this meeting. We will allow 3 minutes for comments, and we'll let you know when your time is almost over. Katie is over on this side here. Katie, can you wave? Katie's here. She will let you know when your 3 minutes are almost over, and she will signal you so that we will not be here till midnight. We ask that all the participants in this room abide by the following rules. We ask that you be respectful of all the speakers. Please refrain from speaking out from the audience. Please also refrain from side conversations as the acoustics in this room carry. Please speak in a civil tone. We understand this is an emotional topic, but we need to remain calm and work in an atmosphere of mutual respect. It is always easy to find issues where we can be critical, but we're looking for input that may help find a solution. So at this time, I'll call upon Mr. Frampton. You will have the podium, and I'm going to turn off my mic because we don't really need to speak until the end.
Is this on?
Yes.
If I talk loudly into that, can people hear me? How about in the back?
Good.
Can you hear me?
Mhm.
Does that work?
Yes.
Thank you. I'm George Frampton. My wife, Carla, and I are the owners and fee simple of 12 Tantamaheg Road, 19 Tantamaheg Road, and the parcel that lies in between, which contains our back driveway, sometimes called Tantamaheg Landing. I'm trying to explain tonight why the temporary standstill agreement that we've reached with the town is not only in the town's best interests, it's really can be a win for the town. But to do that, I have to try to stress and make sure everybody who's listening understands 3 basic facts. One is, to begin with, you never know it well from all the social media trolling that's gone on over the last 2 weeks. The ownership of our back driveway is no longer an issue in this dispute. No longer an issue. On August 2nd, 2022, the town's council stood up at a board of selectmen's meeting and publicly acknowledged there's absolutely no evidence at all that the town ever had or has any ownership interest in the so-called Tantamaheg Landing. It's in the minutes. Town's written a letter to us. Happy to show it to you. The issue is not on the table. We in the town have moved on. Anyone who doesn't understand this and has made an effort to convince you that the town owns Tantamaheg Landing is blowing smoke. Second, it's finally dawned on the town, I would say, that the cockamamie theory had advanced. It had to advance publicly when it conceded that we own it. They don't own Tantamaheg Landing. That our back driveway has been a public highway for 300 some years based on a 1701 right of way, supposedly mapped in 1931. That theory has vanished. It was always a bit of a Hail Mary pass, for the town, because every single official, public, local, state, and federal map since 1886 to define what is a road or a highway in online, what is private property. Hundreds of those maps, every single one shows the Tantamaheg Road runs down to our property, stops, turns right, goes up the hill, north. Doesn't go on our back driveway. But we found a year ago why it is that those maps, those funny maps, look that way. We found the original official documents showing that in 1712, the 1701 right-of-way wasn't being used. In fact, it couldn't even be found. And the town was upset. And it said to Richard Lord, the town owner, well, we're going to make you start up, lay out a more robust, more useful right-of-way. And he agreed to do that, but only on the condition that the town hand back the 1701 right of way and guaranteed that the new one, the 1713 right of way, would end on his death. Died in 1727, he made clear in his wills and his deeds to his children that no right of ways. There haven't been any right of ways anywhere near us since 1727. But third, and perhaps most important, and perhaps most widely misunderstood, is the fact that government entities, towns, cities, states, do not have adverse possession or adverse user rights like individuals do. Even if they've adversely used private property, they have no typical individual rights. So the fact that Old Lyme has used and invited people to use Tannenbank Landing for decades is totally irrelevant under American law in claiming any right going forward. In our country's law and in Connecticut's law, a town that wants to claim that kind of right going forward has to convince a court, federal court, that it has a compelling need to confiscate or take whatever private property right it wants. And if it wins, it has to compensate the landowner. So if Old Lyme wanted to go that route, it would have to convince a federal judge that it has a compelling need. Old Lyme, could barely operate without running cars and trucks down our back driveway. Pretty tough case to make. Take a long time, be very expensive, probably a loser. But if the town won and got the truck and car passage on our back driveway, they would have to compensate us for what they had taken. Bottom line, where we are with the town is the town has no ownership rights in the landing. And it almost surely has no access rights, but certainly doesn't seem to have a mechanism for getting to court at all. Another way to put it is the town is probably dependent on us, a private landowner, for our voluntary concession to secure pedestrian access, which we support and we want to have. And we've said that from the beginning. You don't have to accept this from me, though. Not at all. You can simply see what the anonymous lawyer, famous anonymous lawyer that the Connecticut Examiner dredged up from someplace in order to write a hit story against the town and the agreement a couple of weeks ago. You can look at what the anonymous lawyer had to say in the Connecticut Examiner. And what he tells you in that story, his analysis, is exactly what I've told you. The same 3 points. We own this property. That's a premise of his entire analysis. What about the public highway theory? He doesn't mention it. Why not? Because he knows the town could never go to court with something like that. It would explode itself. It would probably get fined for frivolous litigation. Doesn't even mention it. And third, most important in the article, happy to promote the Connecticut Examiner, he examines why towns don't have adverse use rights and why the town of Old Lyme, if you wanted to, would have to go to court and confiscate our property. And he points out, attempt to do that without the confiscation is probably, quote, unconstitutional. That's his word. Exactly. The only thing left, he says, is a bunch of individuals could put together a joint suit, pieces of string into a string ball, and bring an adverse possession suit. What he doesn't say in the article, though, is the price tag, $30,000 to $60,000. They add a couple zeros to that. That's $1 million lawsuit at best. The other thing he doesn't tell you is never been done in American law. So if somebody's got $1 million, they want to bet on this case and trying to establish a brand new principle in American law and Old Lyme, power to them, we'll oppose it. So if you credit anything the anonymous lawyer says, I think you'll understand why it is that the town really has a problem here in figuring out what to do to get the court to assert any rights, even pedestrian rights, which we want to establish. As a result of this predicament, for 3 years, the town has constantly and consistently threatened my family's safety, security, privacy, and private property rights. if not every day, every week and every month. Instead of coming clean about the situation or keeping the public updated, the town has for 3 years been following what I'll call Plan A. Plan A is ignore, deny, and intimidate. And I call it Plan A because I have a reason to think that's what it's actually been called at town hall. Ignore any evidence we come up with. Deny that the facts or law are binding or that the council has to obey the law. And threaten and intimidate us. Intimidate us to do what? Either give in, give the town what it wants, whether it's entitled to it or not, or sue the town, or sell our house and move away. But 3 years later, Plan A hasn't worked. And continuing it isn't going to work. It's going to crash. And that's why a temporary timeout, which is what we had hoped for here, a standstill for a defined period of time, short time, a year, could be 9 months, will allow, it's a good idea. It'll allow 99% of what people really want to use our back driveway for over the next year. 99% of the access that anybody's really used before or wants. It gives us and the town, for the first time ever, a chance to try to work out a settlement that serves everybody's interest. And it allows the town to become a little bit more educated about what's really at stake here. It makes sense. The town gives up absolutely no rights whatsoever, nothing. After that period, whatever rights the town has, wants to pursue them, and can pursue them. Well, instead of a rational discussion about the merits of this standstill, we've been sort of caught up in the last few weeks in what I would say is a vitriolic partisan political gang war. Judging by circulated petitions and social media, mostly based on misinformation put out by people who didn't really make the slightest effort in the beginning, to figure out what's going on here. One thing town officials do know, but the public doesn't, is while the town may have some real problems getting to court at all to enforce the rights that it was allowed to enforce, we don't. And it's not what you think. The last thing we want to do, is to sue the town or be involved in any way for or against the town. But we do have open to us, and the town knows this now, a very robust potential civil rights action in federal statute, in federal court, to compensate us what's been done to us in the last couple of years under Plan A. That's a normal type of case brought by plaintiffs against local governments of all kinds for egregious government outreach, whether by police departments or town councils. We've read about these cases all over the country. A recent case in Virginia, for example, strongly endorsed by the Federal Court of Appeals, is identical to this case. A town which joined with sort of individuals and vigilantes to enforce and intimidate the landowner and enforce a right of way which they had reason to know really wasn't valid. That was a $4.5 million case only for compensatory damages. But these cases are very familiar to federal judges. And I've brought 12 or 13 of these cases myself. They're quite common cases. And lawyers love the case because the statute gives you the right to get attorney's fees if you win any part of the case. So lawyers always take these cases, not on a fee basis, but on a basis that they're working on your dime, not the plaintiff's dime. And they hope to recover damages, which are by law under, all the reasonable time they spend at commercial rates, $600, $900 an hour. Normally one sues not just the town, but members of the boards who did the damage to you in their individual capacities. These are conspiracy cases. You sue private individuals too. It's a mess. We didn't move here to litigate with the town. For heaven's sakes, or get involved in partisan political gang, which seems to be what's happening here in the last couple of weeks. We moved here to live in peace and hopefully to make some contribution to this community by, what we could do here. and friends we had made 25 years of coming here and moving. And what we thought was a law-abiding government. So I just leave you with this thought. It would really be a tragedy if responsible citizens of Old Lyme or its public officials end up being bullied, intimidated, or frightened by this mean, ugly political battle that seems to have sort of seeped into town like, a noxious gas over the last couple of weeks, and caved into a misinformed public opinion that is driving it, rather than really considering whether this standstill agreement is in the best interest of the town. An agreement in which the town gives up nothing and may be the only path the town ever has to acquiring long-term pedestrian use. To throw this agreement into the trash can now would be a shame. I would say to you, it would be a stain on the town's reputation. It would be counterproductive. And it would be just stupid, really stupid. Don't do that. Don't do that. Give us a chance to work together. Thank you.
Thank you. Kim Griswold, you are up next.
During my 18 years as first selectman, I've been involved in two volatile issues concerning Tanmaheg Landing. First was Diana Johnson, who proposed that the town should surrender its interest in the landing in return for her giving the town a gravel pit at the Black Hall River. So because she had a written offer, we brought it to a town meeting, which was held in the church during the renovation. Well, at the start of the meeting room was packed, just like it is today. And we heard a torrent of opposition to that idea. Not surprisingly, the selectmen voted later to decline Ms. Atwood's offer, and things returned to normal. Well, fast forward to today, a bit of deja vu. The selectmen have scheduled a public hearing to consider George Frampton and Carla DeRista's position and have a non-binding resolution, the MOU. Not long after the abutters informed the town that they own the road on which the landing sits in between their two parcels, they performed exhaustive title work, and they concluded that Tanmaheg is theirs. And in fact, the town had abandoned the road long ago. However, they were doing a neighborly thing by allowing public access, pedestrian access only to their landing. The town with its council looked into this, and we had a very capable title attorney who looked into it at great extent and cost us a bunch of money. And it was the opinion at that time, and I think may still be, that regardless of who may own the underlying real estate, the town has a valid interest in the road, right away at the actual road improvements. Well, during the time that this was all going along, the town did not make any improvements which were contemplated, such as parking and other improvements. But the abutters were very busy planting shrubs and trees. They erected a stone wall over the boundary line. They trimmed trees out the front to make a better view. And we had to remove these shrubs and stuff from the landing because it constricted vehicular access. Well, they came and put them back again. So we had Public Works take them again, and they went one way for good. So I think it has some serious flaws. Let's see, no vehicles are allowed except emergency. Handicap parking? No. The abutters will maintain the landing. No other road is maintained by private people. Visitor parking out in front of the pillars, not much space. It's probably 75-yard walk. And then you have signage on the front. There's no mention of public access. This having a mediator try to come up with a compromise. We know our positions, they're pretty clear. So I think the positions are polarized, and I think we spent enough money. We've talked to enough lawyers, and I think selectmen should proceed with the implementation of the selectmen's and harbor management's plan for the landing.
Next up is Daniel Jones.
Good evening. For the record, I am Daniel R. Jones and we reside at 10 Old Post Road, Oline, Connecticut. I own 26 acres of land up there. My parents bought it in 1949. A lot of work went into it, and there has been a lot of heartache, some of it down here in this town hall. We ended up Stagecoach Road used to come out on Grassy Hill next to Brown's house. Well, the builder decided he was gonna start building some houses halfway up on Stagecoach Road. And sure enough, it started causing problems because when Bud McCarthy was a selectman here, Bud said he was going to give them carte blanche on putting in a road. Which, come to find out, my family had to hire a lawyer. And we ended up prevailing. The town came in, started cutting down trees, causing damage to the stone wall on the west side of my property. And we had to get that taken care of. We hired a lawyer by the name of Granville Morris from Stewart, Barnick and Kelly. At that time, they were resided out in Groton. But there's got to be a resolution. There's got to be a final. Because what I found very funny is that this is two parcels of land, actually, if I'm reading this right. One's 12 and one's 19. This woman, she's got quite an expose. She's done a lot in this town. And I find it very surprising that she didn't make accommodations for that little pivotal land that a lot of people like to go out there, watch the birds and whatever else. I'm getting a 30-second warning. So anyways, I gotta agree with Timmy Griswold that take this into fruition. Anyhow, I'm done.
Thank you.
I got paperwork if you want it.
Put it in the minute.
I can put it in the minutes if you've got it printed. You
I
want,
got it printed.
you want? Okay.
Thank you.
Next up is Mr. Thomas Gutaqua.
Yes, my name is Tom Gutaqua.
No, can you come to the podium, please? Thank you.
Yes, I'm Tom Gutaqua. I live at 25 Library Lane, which happens to be on the banks of the Mighty Duck River. As I recall, my undergraduate days, there was a philosophical principle called Occam's razor, which indicates that in a dispute like this, you find the simplest, least complicated solution, which I think this memorandum of understanding lays out very nicely. It meets both of those criteria. And it seems that either the Framptons or the town will lose face on this. So I certainly am firmly behind this understanding, and I hope that we move this to fruition.
Next up is Carla DeRista. I'm sorry, Terry Lewis is next. Sorry, Terry Lewis, please.
I didn't realize that we had to make this in 3 minutes. I think mine's 5. So I'm gonna have to skip over the MOU other than the fact that I don't agree with the MOU. But as I stand here today as a concerned citizen, but as someone who has a profound personal connection to this property, over the years, I have been a friend and part of the life estate of the previous owner, Diana Albert Johnson. And I have been intimately involved in the care and the stewardship of this land. During the final years of the previous owner's life, I was entrusted with the responsibility of assisting her with her medical needs and the management of her personal estate. I became well acquainted with every inch of this property. I know every mirestone, I know every pin, I know every tree, I know everything about it. During her final years of the ownership, not only was I entrusted, but I was entrusted after her passing. I played a pivotal role in ensuring a smooth transition of the estate, working closely with the estate lawyer, Diana's family, and other parties involved. And when the new owners arrived, I served and still serve as chair as a harbor management board, and was acutely aware of the significance of the swallow season, a natural spectacle cherished by our community. In the effort to maintain harmony and respect for the property's boundaries, I personally met with the new owners to discuss the importance of the landing and the community's traditions. Despite these efforts, it has become increasingly clear that the new owners have chosen a path of resistance, erecting barriers, questioning the historic public access that has been a hallmark of Tangipahoa Landing since the 1700s. And I'll pass that information on to you as well. Lots of information that I have. In an effort to maintain harmony and respect for the property's boundaries, I've also taken action with the new owners. These actions taken by the new owners, from constructing stone walls to removing property markers hindering access, are deeply concerning. It is my belief that these measures not only disregard the town's history, but also represent an aggressive overreach into public space. My goal is simple: just to see Tangipahoa Landing restored to its rightful state as it was at the time of the sale, knowing the access was there. This includes the removal of unauthorized structures such as stone walls, shrubs, installation of possibly a fence to help delineate property lines, and the return of signage that was once clear, an indicator of the landing's public nature. These were ripped down by the new owner. We can't get back the trees cut down on the town landing or the limbing of the trees, but we can clean and clear the walls, shrubs, and the other personal property to its original state. I have witnessed firsthand the changes that have taken place, and I cannot stand by as the legacy of this land is rewritten. There's more than a dispute over property. It's about preserving the piece of our town soul and ensuring that the future generations can enjoy the same access that the cornerstone of our community
I'm in for you.
presents. I have some information as well as great information from our title searcher that contradicts everything that Mr. Frampton says, and also some information that goes back, some great literature from 1876 for the Lord property, distinguishing the highway to the river.
Will you give it? Mhm. Next up is Carla DeRista.
Good evening, everyone. I'm Carla Drista Frampton, and my husband George and I are the owners in fee simple of the back driveway between 12 and 19 Tangipahoa Road. Ostensibly, we're here this evening to vote on an interim agreement that would provide legal pedestrian access to our back driveway. But petitions, Facebook campaigns, social media posts, and vigilante journalism have once again turned this issue into a referendum, not on our private property rights and any illegal pedestrian access the town would have to our back driveway by right of this agreement, but on who won the last election, who swore that they didn't win it, and who wants to win the next one. We're right back to where we were years ago when we presented town officials with incontrovertible proof of our ownership of our back driveway. And there was never right of way on our property. And Tim Griswold reported in the press is commenting something to the effect of, well, if the town's made a mistake, we need to take a look into it. And the next thing we knew, we were in the middle of another maelstrom of misinformed public opinion and even more trolling cars and trucks. And when I asked him why he was fueling the fires by refusing to level with the townspeople and kicking the can down the road, he looked at me and he said, you know, these people are brandishing pitchforks. And he kind of shrugged, and it was sort of clear that basically better you than me. Then, as I know now, that a majority of town officials really just don't have the backbone to stand up for the inconvenient truth of this matter. We were then, and probably will be now, thrown under the bus, the victim of really divisive town politics. After all, as town officials have reminded us on more than one occasion, we're the outsiders here, we're newcomers. Who's going to risk their neck and stand up for us? Why expend political capital on an inconvenient truth? And I have to admit my skepticism when I actually met Jim Lampos, and he basically echoed a lot of the basic facts of this dispute. And then I realized Jim is not a politician first and foremost, he's a historian. And he is bound by the tenets of his profession to archivally find the truth and report them. What I hope will happen in the long run is that you're going to pack up your pitchforks, divisive partisan politics, ideologies, left and right, that ignore private property rights, harbor management power plays, and real estate ads that purport to market your houses at the expense of unfettered access to mine, and put them in your campaign buds and roll out of our back driveway. Because, you know, we're actually not newcomers to this wonderful town. We moved here permanently, but my husband and my stepson have gone to college in the area. My mother's lived here for over 30 years. We have many town friends, and we've added many new ones, and we've become very involved in the wonderful cultural institutions that make this such a fabulous community. And we're hopeful that when all these unconstructed power plays and partisan politics are finally put aside, the town will admit that Tanamahaig Road is Tanamahaig Road. It's not our back driveway, and once again, become the peaceful, well-managed, law-abiding town that we all know and love. Thank you very much.
Okay, next up is George Ryan. Not going? Okay. Gary Gregory. Are you coming up? You're on the list.
Gary Gregory, Browns Lane, and came here to find out what's going on. I've been involved with this project for 4 years now. I'm going to plead to the Board of Selectmen to fight this situation. All my kids grew up on Colt Lane during high school, and they were down there every day during the summer. I don't understand how somebody comes to town and try to take land away from us that we've had for 300 years, Mr. Clinton there. I don't know why anybody would do that. Except I looked into your background a little bit and I found out you're one of the elite liberals from Washington, D.C. That kind of explains it to me. Else we everything for you, nothing for these people. Lewis just left a package over here that she said that material is contradictory to everything you said. But I don't know what the true story is, but I know I can't vote on it if I don't know what's in this Lewis's package. Thank you.
Next up is Andy Russell.
My name's Andy Russell. I live on East Swanswood Lane. Wife and I and our family have been in town for 31 years. I've been to Tanamahaig one time to the landing, but I've been in the house when Diana Johnson owned it. Meetings, social events, beautiful spot. Congratulations on that. The one thing that stands out to me, Diana did what was best for the community. And as Mr. Griswold said earlier, she tried to work a deal with the town because she knew that was not her property. And she made a generous offer for a land swap because she knew that was not her property. If she thought it was her property, she believed me, she would have fought for it. Very bright lady and did a lot for this community. That's, I think, one of the most important things we need to remember is she knew it was not her property. Thank you.
Michael Barnes?
Good evening, everybody. My name is Michael Barnes. I reside at 14 Road. I'm here as a resident tonight. I do serve on the Harbor Management Commission, but I am not here speaking on that behalf. I've had a couple run-ins with you folks, and I do question this MOU and us moving forward with it with some not so confident in the information that's been presented to us. I've read the title report from the town council that we have, and they were pretty clear in that. But one thing I do question is in 2021 or 2020, you guys had submitted stuff to the town for an addition on your home. And at that time, you had to submit site plans, which were stamped by engineers and licensed surveyors, depicting that the information was accurate. And in those site plans that you guys had submitted to the town, it shows specifically your land is 2 parcels with a town road through the middle. I kind of question how we're here now, and you're claiming ownership. I guess if you would have known at that time, why would you have submitted documentation to the town for these site plan approvals, showing it as 2 separate parcels with the town owning it in the middle? I think that's a very important thing to note here, because that's not accurate information that you're presenting in a zoning environment. I have 3 sons that are in the back over here. Those are the reason I showed up here tonight, because the future generations that aren't here tonight in this building or aren't even born yet are going to be affected by the decision that comes out of this meeting. I think that's extremely important. There is a process through the land use court, which my understanding is we're kind of being threatened with a civil lawsuit, and I feel a lot of bluffing. I don't know if it's bluffing, it's probably true, because that's your litigator, so power to you. But I think that we should call them out and take them at their hand and fight this in court. They have a process to suit the quiet title. We've talked about that. I understand they might not want to take that process, but I think that that is an avenue that should be explored. I just don't think it's fair. This MOU, although I give Jim a lot of credit, he worked really hard to negotiate this. I do not think it's in the best interest of the town, and I really hope that you guys do not sign. Thank you.
Next up, Randy Nixon.
Evening, everybody. I've lived in Old Line for 42 years. I've used Tanamahaig Landing many times with my kayak. Had problems with John Johnson with access years ago, and that went away. And now here we are again. We have 2 diverse legal opinions. I don't that everybody in this room should buy everything that you heard with the disproportionate amount of time given to these other folks. But at any rate, we've got 2 very diverse legal opinions, and we should not kick the can down the road with this agreement. We should vote against this MOU, and we should move forward from there. Thank you.
Next up is Matty Matson.
Hello, everyone. My name is Maddie Matson, and I am a Realtor with Caldwell Banker Realty in Old Lyme. I've sold a lot of property along this street and streets that abut it to other people, and we've always come across the subject of, well, can I walk down there and go fishing? Yes, you can. You can't drive down there because there's no place to turn around. It's very dangerous, but everybody in the neighborhood can walk down here. I sold this piece of property to Carla and George with the understanding that the people in the neighborhood for years have come down here and used it. Lovely, fine, but not trucks and cars parking in an area that is very dangerous. Evan Griswold himself called it a mud suck. He said, this is not a good place to put in a canoe or a kayak. It's dangerous. So I'm very in favor of this MOU, and I think it's a wonderful solution. A temporary pause. Everybody calm down and see if we can mediate this in a reasonable manner. Thank you.
Next up is Bill Bolland.
I am Bill Collins, 6 Mountain Lane here in Oline. I am somewhat perplexed by why we're here, why this agreement been brought to us. Is it, has the selectmen brought this to us because they're not sure of their position, legal position, if this would go to litigation? I think the selectmen have got to be a little more honest with us on why we're here. Is it because the litigation comes with a cost? Sure. If the town is so sure of its position that it's held for 4 years, I believe that the overwhelming majority of residents in town, including myself, would rather see this resolved in a court of law rather than be kicked down the road. We be back here again. I believe in 4 years, the town and the owner of that property has been unable to come to a resolution. It's time to litigate this at court. And I, for one, am willing to open my wallet and pay, although I don't want to, whatever it requires to bring this to a resolution, whichever way it goes. Thank you.
I think it's Selma. Selma? Yes. Selma, how do you spell your last name? Goodman. Okay.
Hi, everyone. I'm Salma Goodman, and I live on Freeport Lane. I did not think this was going to be a speaking engagement, so I wasn't sure why I was here, but I was going to support Freeport Lane, and all the residents on that road. I'm certainly not a politician, so I don't know all why this is turning into political argument. I am not a lawyer, so I don't understand all that jargon that's going back and forth, since 1726 or whatever ridiculousness that is. All I can say is I had 3 kids. They were very little when we moved on to Colt Lane 14 years ago. And we would walk down there. It was a very peaceful place. It was a lovely place to take the kids. They would throw rocks in the water and we just had a lovely time. We would stroll back. Never in my 14 years, even when I went there during the swallow season, was it rambunctious. Yes, were there cars there? No, it was not dangerous to turn around. I never saw anyone sinking. It really bothers me, the exaggeration that has gone into this deal. It was a peaceful town. It was a quiet town. And it was until 4 years ago when that property was sold. And it's turned into this nightmare of political, legal jargon. We'd like our life back. We'd like our quiet town back. We'd like our quiet street back. And hopefully the town can figure this out for us. Thank you.
John Atkinson.
John Atkinson, 14 Colt Lane. I have something that's quite a bit longer than 3 minutes. I will submit it for you. It's in writing. My first question is though, why both the newcomers get 18 minutes and those of us that have been here for 30 years or more who have already given you a lot of information get 3 minutes? That seems to me to be unfair. I understand that you all have been over backwards to accommodate them. But we didn't need 18 minutes of hectoring, lecturing and condensation. What's that?
Condescending.
Thank you. Memorandum of understanding is only useful when the parties are acting in good faith. Mr. Frampton, Mr. Rista, you have not acted in good faith. You have planted shrubberies where they don't belong. You've intimidated your neighbors. You've called the police, including on me. You have lied to the police, Mr. Rista. That is not the way neighbors act in Old Lyme. In Old Lyme, we don't take what doesn't belong to us. And if you threaten us, as you did tonight with a lawsuit, Mr. Frampton, that only encourages us to resist. Thank you. That's 3 copies, 1 for each of you.
Thank you.
And I'm going to include it in the minutes. Okay. Fred Benton, please.
My name is Fred Patton. I live in Old Lyme. I just have a couple of questions. One, was there not something in the deed when you purchased the building that reflected the situation? And if so, when did this become a problem? I'm sure that information is easily communicatable. So, thank you.
John Meacham.
John Meacham, 6 Flat Rock Hill Road. I've been a resident for 30 years. I'm a retired state trooper and apparently now have been elevated to internet troll. So I will wear that proudly because apparently I have committed the scurrilous act of using the internet and its power to notify the good people of Old Lyme that there was a 2-week window to address this matter and started an online petition calling for a no vote on this MOU. So as of 3 o'clock today, there was 344 people who signed this petition urging for a no vote. Since then, it's risen to over 350. I've sent this electronically to each selectman, and now I'm going to hand it to them and ask them to put it into the meeting minutes after I leave the podium here. I do thank Jim for his efforts. I understand, you know, the impetus behind this, but this MOU is not the deal for Old Lyme. It has not changed the status quo for the residents. It does not change the status quo for anyone walking down there and using this. What it does do is give Mr. Frampton an open-ended ability to petition the Board of Selectmen in executive session. I don't think that's what the people of Old Lyme is. They deserve transparent government and a deal out in the open where we can discuss and talk about it like we are tonight. So that is my biggest objection. There's been plenty of other objections. I'm not going to go over each and every one, but I hope the board will vote no tonight. Thank you.
Next up is Paul Reed. Watch the cord. Thank you.
Paul Reed, 9 Colt Lane. Been living on Colt Lane for about 20 years.
So when the current owners moved in, I'm a runner and I run down that area quite often at that point in time. I was doing short runs, so I was down there relatively often. Within a day or two moving in, the sign that said Time to Mahake Landing was removed and a private property sign went up. And that was immediately. It was during swallow season. So they moved in during swallow season. The house had been vacant for 2 years. A lot of residents had gotten into the bad habit of maybe encroaching onto the property, and we're still doing that. That was a habit they had. The residents felt intimidated by that. They didn't like that. I totally get that. That was something we needed to deal with. It wasn't until a year and a half, 2 years later that they did some research that they said, claimed that they owned the property. So initially, this was a problem with people encroaching on the property. They said there were cars coming down all night long and trucks speeding up and down the lane all night. But never was there any data taken on any of that. And nobody sat down there and counted cars or anything like that. Before they moved in, and between when Johnson tried to trade the property and they moved in, it was a very quiet place, as Mr. Goodman said. People would go down there, walk down there, people go down there. Occasionally a car would down there. There was some elderly residents on the street who couldn't walk down there, but liked to get a good look at the water on their way home once in a while. Drive down there and park and watch for a couple of minutes and then go home. Have a nice blue water. There was very little traffic down there without this controversy. The problem was created when they tried to keep everybody out. And that's why more and more people went down there. As soon as it shows up in the newspaper, people want to see, well, what is this thing? I never heard of Time to Mahake Landing. I've never been down there. They want to see what it is. They go down there. That created the problem. So I want to go back to something Terry Lewis said. You don't remember when we were little kids playing games? Remember the do-overs? Let's go back to the conditions at the sale. Let's set everything back up that way. And let's do this methodically. Let's wait a few months till things calm down and let's see what the traffic is down there. Are there a lot of cars coming back and forth at night? Are there a lot of people in there? And then let's deal with that so that the residents have a proper amount of privacy. They deserve that. We bought those 2 pieces of property on either side of Time to Mahake Road. They deserve their privacy. That's all I think. Thank you.
Stephen Dix.
I live at 2 Colt Lane and I've been there for 31 years, this month. One of the reasons I bought the house was the neighborhood, the park over the hill by Mr. Lohman, who I got to know. Go out there when he was clearing the trees, trimming, whatever. And I used to go down to Diane Atwood's place and hang out there. And when she left and the house became vacant, I used to spend more time down there. But as soon as they moved in, I noticed the change. Going, what's going on here? And so I stopped by to visit with them and talk to them and try to get to know them during COVID time. And I found them very pleasant to talk to and wanted to get to know more and enjoyed taking my walks with the dog down there all the time. So I had none of this violence or whatever experience that people are talking about. I never saw that. But what I have noted for 30 years is that the land is underutilized. And that's what one point I wanted to make here. I always wanted to put a dock down there. I was trying to figure out how can I do that? Should I go over the edge, the steep bank on the right by the waterfall or the dam? How do we do that? So I think, my need is, or observation is, we need to give Carla the security that she needs to be comfortable in. So we don't have the traffic, we don't have the confrontation. And at the same time, we need to have access to the water that's usable. And I think there's some ways we could explore that working with the Harbor Commission. So we have a usable ramp or what I'll call a kayak dock or whatever it is, so we can utilize the property and at the same time
develop some type of partition or fence or something that gives them the security and privacy that they want. So I think there's some solutions here, and we need some time to explore those. Those are complex issues that involve the DEP, permits and other things, and we need to talk about it, but I want more full utilization of the property than it is right now. We shouldn't be just fighting about it. We should be looking for a much better solution and productive use of this land. And I'd like to work with George and Carla and try to make that happen. So this MOU will allow us to do that. I think it's a step in the right direction.
Next up is Kimberly Thompson.
Kim Thompson, 2 Littlefield Lane. I didn't prepare anything to say. I mostly wanted to comment that, you know, I live in the neighborhood. I think I'm the only one from Littlefield Lane here. I walk down there all the time. I have never had the violent encounters that people are describing down there. I walk down there with my dog at least once a week. But what I have noticed is that when the town has made a statement saying that, you know, that they want to talk about parking down there, that they want to talk about access down there, that they want to talk about these things, that all of a sudden large shrubs, big walls, large plantings that are going to get in the way of exactly where the town talked about, let's talk about putting parking in these places, get installed. So I have hesitancy that putting an MOU in place is going to be effective if we have conversations about things and an adverse reaction is taking place. So that's my observation, and I'll yield the rest of my time to others.
Jim Ward. Okay, thank you. Is there anyone online that would like to speak? Is there anyone that's on the phone, online, like to speak? Please unmute yourself if that is the case. Okay, seeing no one at that point. Okay, Jude or Jim, would you, oh, well, that'll be the end of public oh, no, sorry, I'm George. I said that you had 5 minutes at the end. George, would you like the 5 minutes at the end of public comment?
Are you ready?
Yes, you can do that right now.
Well, thank you all for coming tonight. I guess the only thing I have to respond to is Michael Barnes talked about the survey that he used to fix up our barn. That's the survey that we bought the house with. It shows 12, 19, and 10 of May. It's 3 parcels. It is 3 parcels. It remains 3 parcels. But the documentation of the town shows that those 3 parcels were transferred from the Lord family up through various people to us. We bought all 3 parcels. So, and that's what the town's council, after a year of examination, has accepted. I don't know if they're competing with legal opinions. I know what the town went through to get a definitive ruling on that. When I first came in, it wasn't a year later, it was after the town started to say you have to have parking places that hadn't been there before. And we tried to do some research because people had said to us, well, you know, the town doesn't really own that, it's a right of way. And maybe if it's a right of way, you know, there'll be restrictions on that will help you protect your privacy and your safety. So we went out for the first time to do research. And when I went in to take all this material, months worth of work, to Tim Griswold, I said to him, Tim, you know, if it's a right of way, if we own the property, that's gonna be very upsetting to people. And people are gonna be mad at me, and they're gonna be mad at you. But if we own the property, we're right. Then, perhaps that certainly changes the situation. There may be limits on that, on a right of way, to give us some protection. It's a different discussion. And you should give this right away to your lawyer. And vet it, because if we're wrong, we're wrong, but if we're right, then we should have a conversation. But you and I should talk about this instead of going public. Maybe we can start, avoiding a struggle about what this means. And Tim, sorry to say, put it in his desk drawer, pretended that he never got it. And when some of the selectmen asked him about it 2 months later, he admitted that he had hidden it. Well, then it went to town clerk, and for 12 months, basically 13 months, 14 months, I think, 14 months, every month, town said, we own it. We own it. Town lawyer knew, town doesn't know it. It took them 14 months to finally admit that the town owned it. But by that time, it was a public highway, and there was absolutely no willingness to have any discussion about anything. In fact, we've never been able to have that discussion, ever in public, with anybody from the town. We've offered to have discussions, we've offered to mediate, but the town has never been willing to expose any of this to an independent arbitrator or an independent mediator, never, in 3 years. So that's what we're hoping, that a standstill agreement, a little bit of a timeout, a pause, will give us, for the first time ever, an opportunity to engage in a discussion with the town. And an opportunity to help find a way that we can work together, and that the public can understand a little bit better what's really at stake for both sides. So I hope that's made an impact. Perhaps it hasn't. And I guess in closing, I'd like to say, not sure what the intention of the selectmen is, but I would urge you to consider waiting to vote until next week and seeing whether to reflect on what's happened today, good and bad from my point of view, I suppose, and see whether what you've heard makes a difference to you. That's not under my control, obviously, but I think it might be prudent to take a little bit of time over the next week and reflect on this. Thank you.
Okay. That is the end of public comment. Jude, would you like to say anything?
A couple of things outside the legal conversations and who did what bothers me. I don't think this is a Democratic or Republican issue. I think this is a town issue. And the reason why I asked that we do this is I think it was important to all three of us that we hear how the public feels about this. This should be discussed in public, and the people who have something to say have an opportunity to stand up and speak. So when someone said, why are we here tonight? That's why we wanted the public to have some time to weigh in here and let us know what they think, how they feel. And thirdly, I agree with Andy Russell. I spent a lot of time not being a politician, but I'd like to say volunteering. This is the first time I've ever been paid for anything I've done for the town. And I spent many occasions at Diana Atwood's house, who did a lot of good for the town. And for her to recognize that this piece of property was not hers and was willing to make a land swap speaks volumes to me. So with that said, those are three things that stand out in my mind. Thank you.
Jim?
First, I'd like to thank everyone for coming today. It's really great to see a turnout, and I mean that sincerely. Getting everyone's opinion, getting everyone's feedback and being involved, I think is the most important thing you can do as a town. So if you'll bear with me, a lot of people are wondering, why are we here? So I would just like to run down at least my logic and how we got here and why we're all gathered today. And I'm sorry. Okay.
It's reverb.
Yeah, too close.
So I'll try to keep the history brief. I'm going to very quickly talk about the past, and then I'm just going to focus on the dispute itself. So reference to Tanamahaig Landing first appears in the town meeting minutes of this Board of Selectmen, May 28th, 1679. Much earlier than 1701 is the first divisions of land in the town. Quote, John Lord is granted to exchange 10 acres of land at the falls for 10 acres on the south side of Tanamahaig's Brook, not prejudicing a highway to the river. So that this democratic body, a meeting of townspeople and its representative board, can refer to minutes of its proceedings nearly 350 years ago, a full century before the founding of the United States, makes us acutely aware that we're duty bound to our posterity. With 300 and 350 years in the future, may well be looking back on these proceedings today and taking note of what we've done and said. So this is, I believe, a serious issue. And that's why I sincerely thank everyone for their opinion and for being here and participating in this process. I think it's very important for us to do as a town. So it's with that charge of protecting the interests of this town and the well-being of our citizens that we approach this question of Tanamahaig. At no point have I or anyone on this board offered or agreed to cede any of the town's rights. Our purpose and ultimate goal is the preservation of public access to this historic landing, and on that, we're all united. The current question of Tanamahaig's status and ultimately its ownership began in the fall of 2020. Between 2021 and 2023, the Board of Selectmen discussed Tanamahaig in at least 36 of its meetings. At least half a dozen of those being in executive session, with several additional meetings among the abutters, neighbors, attorneys, and other commissions. Now, I want to make clear that I will not be casting aspersions, I will not be second guessing, and I will not be criticizing what happened during those proceedings of the Board of Selectmen. Everyone was doing the best they could with the facts they had at hand. In 2021, there were 15 meetings at a time when the board was only meeting once a month on Tanamahaig. At the September 7th, 2021 meeting, 9 months into the dispute, Selectwoman Nozel and First Selectman Griswold agreed that, quote, the situation's been dragging on too long. On November 15th, 2021, Selectman Griswold reported that the legal aspects are complicated. In 2022, there were at least 9 meetings, 2 of those being in executive session. On May 2nd, 2022, First Selectman Griswold reported that, quote, work is being done that cannot be discussed. On June 6th, he noted that work on the title is ongoing. Quote, pedestrians should be welcome to visit this property. Vehicular access has been and is a major issue. August 1st, 2022, Attorney Collins reported that there are no deeds giving the town title to Tanamahaig Landing. On November 17th, 2022, Mr. Griswold offered that he is, quote, exploring the use of the Attorney General's office in resolving the dispute. Now, some have come to us and said we should contact Attorney General Tong and see what he can do. But on December 5th, First Selectman reported that the Attorney General's services are not available in this matter. And that was a year and a half ago. In 2023, Tanamahaig was discussed at 12 meetings, at least 3 executive sessions. And on June 5th, 2023, the town submitted a settlement proposal to the Framptons, saying, quote, we cannot disclose the details. That settlement proposal, in which the town maintained that it had a valid public highway, included the town's willingness to acknowledge fee title ownership by Frampton in exchange for guarantees of public access along with parking signage, town maintenance, and installation and removal of shrubberies. And the agreement was not accepted by the Framptons. On November 6th, 2023, at the final meeting of the previous Board of Selectmen before this particular board took office, it was reported that the town and the abutters were, quote, at polar opposites. And those are the conditions and those are the legal realities and the facts on the ground that we inherited when we took office this past December. Again, I'm not saying it to criticize, I'm saying it just to lay the situation as it was as we found. Nevertheless, 2 weeks into our term, one of the first pieces of correspondence we received is from a member of the Harbor Commission who wrote us to, quote, urge the selectmen to take decisive action to rectify the issues surrounding Tanamaig Landing and to, quote, take the necessary steps to address these pressing concerns. A second member of the Harbor Commission called me personally to urge the same, and a third would also be calling me, urging the administration into action. Now, my conversations with members of Harbor Management were mutually respectful and very productive, and they were valuable. We shared the same goal of ensuring public access, and one can note that their meeting minutes during this period have the status of Tanamaig Landing as being on hold. By the end of March, they had made it known to me that the patience of their constituents was running thin and they needed answers. We had 2 courses of action available to us at that time. We could double down on the previous strategy of the last 4 years, a strategy which had already cost the town $50,000 in legal fees, with little to show except bad press, conflict, confusion as to the status, and resulted in more of the public avoiding the area altogether. Or we could seek an alternative. After 3 months of negotiations, there's now a memorandum of understanding that was cleared by our town attorneys and approved by the Framptons, which guarantees public access without the town giving up any of its legal claims. To clear up misconceptions concerning the nature of the agreement, I would just like to state for the record what the agreement does and does not do very quickly. This agreement does guarantee public access and the right of the people to comfortably and safely walk down Tanamaig Landing to the river. The vast majority of those who use the landing do so as pedestrians. The agreement also includes access to the ice pond, which is definitively the Framptons' private property. It establishes a 1-year cooling off period during which the dispute over ownership of the landing can be brought before a mediator that we could find a volunteer from the town who's knowledgeable on land issues, a lawyer preferably, to hear both sides of the argument and to render an opinion that would be non-binding but guidance for the town. I suppose I'm saying that's the cheap way out, but it would be a way that we could air our case, the Framptons could air their case, and we get a clear understanding of where we are. What this agreement does not do, it does not give away any of the town's rights. Explicit in this agreement is that the town will not give up its claims of ownership or rights of way to Tanamaig Landing in this agreement. And it will not subject the town to protracted and costly litigation that could have uncertain outcomes. Reasonable people can disagree on our course of action. That's why we're here today. Some have told me the town should double down on its previous posture. And if we risk legal bills that could cost the taxpayers hundreds of thousands of dollars and years of litigation, it's worth it as a matter of principle. That's a legitimate point of view to take. This agreement does not preclude such action. It does not preclude binding arbitration, which the Framptons have agreed to engage in. Those options remain available to us, and nothing in this agreement will prejudice future legal actions. The looming burdens of the school renovation project, the senior center renovation, other capital projects, I, for one, would rather choose the alternative that guarantees the right of the public to access the landing while taking a year to rationally discuss the issue with the mediator, explore other options, hopefully find a mutually suitable accommodation, as a lot of the neighbors here today have suggested, possibly moving towards that already, without saddling the taxpayers of Old Lyme with very costly and divisive litigation. In the realm of government, as in daily life, there's a gulf between things as they should be and things as they are. So our ideal situation does not match our reality right now. The ideal for the town has been open access for pedestrians and vehicles, kayakers and bird watchers, and 2 parking spots halfway down the landing at the ice house, and signage information directed to the public. The reality is that there's never been officially designated and marked parking spaces at the landing, or an executed traffic plan or a formal survey of the town's assets with improvements that would make the sharing of the landing between vehicles and pedestrians practical and safe. We've heard in instances where as a standard practice before the Framptons purchased the property, that vehicles would use Diana Adler's private driveway to turn around it. The nature of the road is such that 2 cars can't pass each other in opposite directions. There's no turnout for 300 feet. Misguided tourists with boats in tow looking for a launch have been stuck. While there's been a handful of kayakers over the years who do use the landing on a regular basis, even the Harbor Commission agreed that it's not an ideal place. Make the landing safe for vehicles and pedestrians and to provide the accessible launch area would require a survey, an engineered traffic plan, inland wetlands, deep permits, extensive site work with environmental disturbance, considerable expense. It would immediately run the town into a legal challenge that would promise to be protracted and expensive with an uncertain outcome. It's possible, though unlikely, that the town will get everything it wants. It's also possible that the town could lose more than it currently has. Thus, this agreement, which guarantees access for pedestrians, the vast majority of the users there, allows kayakers to access the river using a kayak cart, albeit not ideal, but you can bring it down on a cart, which is available for $100 on Amazon, and sets up a process by way we can discuss an enduring and permanent solution. Perhaps this isn't the ideal agreement. There's much the town wanted that we didn't get. Those items remain on the agenda for the future. On the other hand, there are concessions that I didn't think we could get, such as the sign of a good compromise. And I guess I'll leave it there. And again, thank you everyone for your patience coming out to listen and offer your opinions today.
Thank you all for your comments. I have a few comments of my own. First of all, I appreciate every single minute that Jim took away from his business and his day off once a week to work on this MOU with George Frampton. I hope that they both learned more about this issue during the process. There are parts of the MOU that I agree with. I appreciate the fact that we're stating that Tantamahate Road is a public roadway. And I am backing on that because the state of Connecticut, since updated as of January 1st, 11th, 2024, agrees that Tantamahate Road has 0.04 unimproved miles and the other is the 0.29 and shows up on our grid map as such. The other item that I do agree with is that it would be a one-year agreement and that we would keep negotiating or finding arbitration or a mediator, perhaps. But I do have some concerns with some of the other sections because I feel that it somewhat is very one-sided and it sometimes favors those people that live at the property. And I understand their concerns about privacy. And as we all know, we all appreciate our privacy in our own homes. I know this, though, that if I went back through the tax assessors and the tax collector's office, no one has ever paid tax on this property for years. Now, I don't know about all of you, but I pay taxes on my property. So somewhere along the way, they felt that it wasn't taxable property and that it was the town's. I think this is a very difficult situation. And I think we've had some other difficult situations in the past couple of years. I think this is a conversation that has to continue to be worked on. If this MOU is decided whether we vote on it today or next week at our regular meeting, this will, if we choose not to, or even if we choose to, the one thing I can tell you that we'll also have options to anticipate meeting with our lawyers again to anticipate our options moving forward. I wish more than anything that we could get a committee together like we did for Horseneck Creek, where we could work together to find a solid solution that some of the people that in this room have spoken today, that we would work together, that maybe the MOU isn't all we want it to be, but can we make it what we want it to be? So if you'd like to be part of a solution to this issue, please contact me. Makes more sense for us to work together than apart. At this point in time, we as a Board of Selectmen group, also I do want to note that I did hear from other people via email, and I just want you to know that I heard from Stephen Ross, Christopher Colangello, Krista Stout, Bonnie Cram, Tracy Ortoliva, John Atkinson, and John Stratton. And they should be noted, and their comments will be included in the minutes as well. So it's now up to the three of us as to how we want to proceed. Anyone?
I feel that I'm hearing two conflicting ideas. One is to work together as a group, people in the room, the community. I'm not sure if that's possible or not. I do feel there's been an overwhelming number of people who want this voted on tonight. And I'd like to make a motion
I'll
to vote
second.
on this tonight.
I'll second.
Okay. We have a motion on the floor. All those in favor of signing this MOU at this time, please signify by saying aye.
Aye.
Okay. All those not in favor of signing the MOU at this time, please signify by saying nay.
Nay.
Okay. All those abstentions, motion does not pass at this time. That MOU